distinguished faculty, I am Prachi Sharma, and it is my deep honor and privilege to welcome you all to the Winter Legal Development Program on the topic the Professional Excellence in Legal Practice at Geetarattan International Business School, affiliated with Guru Gobind Singh Indraprastha University. On the behalf of the institution, I extend a warm welcome to our chief guest, Professor Dr. M. Afzal Wani sir, Pro-Vice Chancellor at IILM University, and our esteemed Professor Dr. Neelam Singh ma'am, and our Professor Dr. Nidhi Sharma ma'am. This year's theme focuses on promoting justice, and as we gather here, it is crucial to reflect on the role of each us can play in upholding the principles today. Before we begin in today's program, I'd like to introduce you to Geetarattan International Business School. Here at GITS, we are committed to nurturing talent and fostering an environment of excellence in education. Our mission is to equip you with knowledge and skills that will not only prepare you for a successful career in law, but also empower you to make a meaningful impact in the world. It is affiliated with Guru Gobind Singh Indraprastha University, Delhi, and approved by All India Council for Technical Education, Ministry of HRD, Government of India for technical courses, and the Bar Council of India for the law courses. GITS has been graded A by the National Assessment and Accreditation Council in its third cycle. As one of the national capital's leading business schools, GITS brings together people, culture and ideas from around the corner to change lives and to transform organizations. Moving ahead, it is both an honor and a privilege to introduce our esteemed guest for today. Sir, Professor Dr. M. Afzal Wani is a distinguished Indian educator and legal expert with a remarkable career spanning several decades. He has served as a member of the Law Commission of India and was the first regular dean of the University School of Law, GGS IPU. Additionally, he has held leadership roles in various affiliated law schools, including Amity School of Law, WIP School of Law, FIMT School of Law. Sir is recognized in Silver Jubilee edition of Who is Who in World 2008 for his contribution to education. With extensive experience in legal education and advocacy, Sir has been deeply involved in promoting legal aid and awareness through his role as Director of Legal Aid and University Coordinator at GGS IPU and as Executive Member of the Delhi State Legal Services Authority. His work with institutions like Aligarh Muslim University, Indian Law Institute and several national universities has significantly influenced the field of legal education. Sir has introduced innovative academic programs including the 5-year integrated law program and specialized courses in cyber law, IPR, human rights. He has also played a key role in developing LLM and PhD programs at GGS IPU. A recognized academic leader, Sir has organized numerous national and international conferences and worked in the law project in Afghanistan as well. Contributions include editing several journals, publishing over 15 books, guiding 14 PhD scholars. His areas of expertise include jurisprudence, comparative law, human rights and legal research methodology. Please join me in giving a warm welcome to Professor Dr. M. Afzal Wani, Sir, who is an individual whose life exemplifies his goal. To welcome our esteemed guest, I invite Dr. Neelam Singh ma'am and Dr. Nidhi Sharma ma'am, the program coordinators of law, to present a green welcome to Sir.
You are saying wages before the work.
No sir, it's not really, it's a very an implication for legal leadership and best practices. Sir, we are eager to learn from you. Please grace the stage.
Dear friends at Geetarattan International Business School and School of Law, I wish you all a very fine good morning.
Good morning, sir.
It's which I am looking for so that I can do some injustice to that. its Bhartiya Sakshya Act Adhiniyam, implications for leadership and best practices in evidence management. I may not strictly go by the provision of law. Let me look to the development and jurisprudence of it, and then how ultimately a law has come up. The best way to understand something is to get to realities. What the realities are. You presented a plant, I can see the shoot of it, but I am not seeing the root of it. What is the root? What is the enjoyment of the root? What is the suffering of the root? What is the functioning of the root? And how I can make it comfortable? How can I make it better? So, you have never in your life respected the root. And the root is more efficient than any other thing. In their background, in their way of thinking, in their feelings, in their receptiveness, in their level of understanding, in their mode of communication. No, but a root in the soil is very discriminatory, if I call it, and discreet, knows which mineral I need and what fruit I have to produce and what shape I have to take. So, we have found laws and bundles of laws coming up. Jeremy Bentham is claimed to be the father of legislation by writing his theory of legislation. Let us give some credit to him. No, it's good to appreciate a scholar. Anyone who does some intellectual effort, we should appreciate. And then all what was happening, he would observe it, convert it into knowledge, and you have a book in hand. So the journey from root to shoots is very important. When we make a law, study a law, we look to its language and few things. We never keep in touch with the soil. We never keep in touch with the issues which are existing on the ground. We never go to the society as such, which is the soil, which is feeding the plant. And that's how he is telling me to speak on leadership and better management of evidence. Shall it happen by reading now, proudly claiming anybody I have added something more to section 63 of the Evidence Act? It will include now electronic evidence, this document, magnetic, all that. Will it solve the problem? Will it make me an evidence management leader? It's having many dimensions. It needs too much of the depth. I also prepared a PPT. I do prepare them. Some people say PPT है, मैं कहता हूँ हाँ है, ये तो कहेंगे ये PPT बनाना नहीं है. But I don't rely on it because then you only roll the slides. It's only in your eyes. It does not get to the heart and mind. And then many people don't remember, so teachers have become dull because it's very good to have the PPT. So you need not now revise also, and you go on reading. And then many teachers are there who now ask the student to read it. You know, this is faculty development program. And what is faculty is not you in person. Faculty is the cognitive capacity of your brain. Cognitive capacity of your mind, that's it. And then you are the cognitive capacity of an institution, so you are faculty. That's how I'm trying to make you understand. An institution is an institution. We say it's our faculty. And what is faculty? It is the cognitive capacity of this institution. Someone Professor Neelam, someone Professor X, Y, Z, these. Professor Dr. Yadav, so many. It makes that. And what's the purpose of the faculty development program is not to read out only the provision and then the same what we do in class, but go to the depths of it. Why do we find that for the last around some 300-400 years, people coming from Europe, and they are monitoring the parts of the world. Just for 600 years, they did not influence a particular part of Central Asia and then in Middle East and this, because that was under Ottoman Empire. They were also very vibrant thinkers and doing it. But then these people developed that cognitive capacity. And where they found here it is hard to get to some places, they took the sea route and reached India and put it under siege and took it over. Ultimately, primarily for business, ultimately to be given a legal system. Ultimately to be given a legal system. The legal system today you possess. It's not yours. It is given to you by somebody. And that's how, if you will read any of the legislations which you find in this part of the world, it has come up like that. And the same is the story of the law of evidence. You did not have any code. No. You did not have any that kind of system of taking the evidence and saying something is relevancy of facts. Something is admissibility. Something makes a legal document. Something is, we presume certain things. Something is primary, something is secondary. Where was that kind of classification? And where from it came? It came only when they got to the bottom. That's what I'm trying to explain. When we talk of developing the faculty, then we have to talk of the bottom and the top together. And then after the FDP, the responsibility of the faculty is to carry it forward, take it ahead, and then be a contributor. Now, when we look from this point of view, then we have to see the overall society. In 1832, when the moorings of establishing of the first law commission under British started, they had the intent to give a formal legal system to the country. And then the legislations formally, if we forget about the regulating act and so on, maybe, that came only after 1857, and then you found many enactments coming into it. Constitutional, criminal, civil, others, and it was that 1872 when the Indian Evidence Act came. Then we talk of good and bad about Macaulay. Very good. We are in anger. We are colonized. No? But there is an intellect. We don't confine it. And today also our classrooms are the same. We don't read. We only feed. No? My dear students, Supreme Court in this case said this, and Section 63 of the Evidence Act reads this. And then in the examination, what is the Section 63 of the Evidence Act? That is the beginning of it and end of it. So, I will read Section 63. You have read it. And go, task is done. But where is faculty development? It is the difficulty development. Perpetuation of difficulty. Rabindranath Tagore, he got a Nobel Prize, no? When? In 1910 or so. And from that day to this day, we don't know how to read and write. And then we had a galaxy of ministers, secretaries, experts, judges, and then we need a law. We need a law for the existing circumstances in the country. Data protection law, evidence law. But we look forward. What is in America? What is in England? What is here? What is there, so that we make it? What is the reason for this? Because there is not faculty development. There is not cognitive capacity in our intellectual, in our scholar. And our scholar, even if he has it, he is not respected. That's why even today, no intellectual was elevated to be the judge of any high court or a supreme court, or to be in very good bodies, decision-making bodies. Professor Yadu should have been a member of Niti Ayog, but he is not. Who would tell them that what's happening on the ground, what is the ground, what should be done? So, the first and the foremost thing in evidence law is, if you don't understand the ground, if you not know the rules of studying the society, if you do not understand the behavioral dynamics of a society, how can you promote evidence management leadership in the country? We go by bad man's perception of law. Neelam sir is good man's perception of law. No? Which provision deals with punishment for murder now? Maybe section 100, 103 or what? So, earlier 302. She would never commit murder. Why? Because she knows इधर कत्ल हुआ, इधर जेल हो गया, और इधर फांसी हो जाएगी. She knows it well. But Jerome Frank's perception of bad man's perception of law, he would think, he knows litigation or prosecution is a process which should have the wings of evidence. So he starts with it. He knows all the chapters of your evidence. He is a more conscious and efficient leader of evidence management. And that's why I skip the book. I skip the book. Prepare in such a way, no evidence is left. Prepare in such a way, no evidence is left. You are an innocent fellow. You are not conscious of getting exposed. Anybody watching, anybody this, anything, any evidence left, you are wrong. But bad man is very much conscious of it. You have made the law, but I am above the law, bad man says. You have the Evidence Act, this is a masterpiece, not for you. This shows me your level, what you can do. But I shall go beyond that. It gives me the norm by which you will, regulate and present the evidence. I shall go beyond that. So, he would prepare in such a way. You are saying we have given in this new Bhartiya, Sakshya, Adhiniyam, too much of technology we have. No, it is full to the brim with technology and all that. No, that is the claim. That's how section 63 mostly and other sections are there. So you will say now, document is not merely a paper document, it is this document, that document, that document, and that document. But he is where? He is there to leave nothing to be traced evidence to be not allowed to come to you. And then once the offense takes place, what then? That will be the evidence. But he knows how to mutilate the scene of the crime. He thinks of it. How to mutilate the scene of the crime. And then, if you manage to make the scene of the crime retain and sustain as evidence, he knows there is not any robot to do it. There is who? There is a very good human being. A very good human being to deal with it. He is called I.O. Do you know I.O.? हाँ सर, आप बताइए the function of the investigation officer. Same evidence again after, and he is not a robot. He is not an angel. He is a human being with his own degree of strength, integrity, honesty, dishonesty, flimsiness, and everything. So, I can manage it or what आप दिखाते हैं डर जाता है. That's how the bad man's perception of law and whole this scenario of evidence, it works in the society. So I can manage, even if you have maintained the scene of the crime, doesn't matter. And before that even, I can manage the police. I can manage IO, and then even if he turns out to be a tough man, I shall manage prosecution. And then, if prosecution is also very stubborn, then I shall manage the judge. And even if judge also declares something, I shall manage the polity, so that you are set free on an auspicious independence day. It is the bad man's perception, Lord. And what does he try to manage at all these levels? It is evidence. Somewhere he claims, I was not there. I was not. That's how is the best way of making to the student understand that how he will understand the process, and then if you will talk and he will say, I was not, and then he will understand alibi they. No? And then a process like confession. He knows, even if I confess to the police I am arrested, it is not binding. That continues in section 23 or 22 of this new BNA. Now, adding to it that it will include electronic processes, documents, and other things, I think it gives some more strength to the law. And no strength to the law, let me immediately say that also. This is a compulsion, because this is the digital world. A paper, hard copy document is now replaced by the digital document. What more is done to make me an evidence management leader? I think that needs to be addressed. If that's not met, that requirement is not met, that shall have to be brought into the scene, into the process, so that we attain the objectives of justice better in this digital world than we were doing. Otherwise, there was no need of bringing a change in it. A Supreme Court judge or a High Court judge could say, when there was no local law, no country law to meet the problem of Vishakha, Justice Verma said that international instruments are automatically to be taken the cognizance by the court in India, even if there is not a legislation. Could a judge not interpret a document includes the electronic document, magnetic document, or it is in any form digital? It includes, and by the stroke of pen in one line, all the purposes of the new DNA would have been served. So, what is on us? How we, the faculty, shall develop ourselves? We shall not develop ourselves by having a parrot-like repetition of the provisions of the Evidence Act, but by getting to the root and the shoot, as I was saying, the society, the process in the society, the social fact, the happenings, the behavior, the thinking, and then the actually, managing. And what are the factors which are monitoring? I was at Kashmiri Cave, and then an old man came with a document. Old document, maybe from some revenue office. He said, ईश्वर की कसम, ये सिग्नेचर मेरा नहीं, ये सिग्नेचर मेरा नहीं। मैंने कहा तेरा तो नहीं है, लेकिन तेरी प्रॉपर्टी तो गई। I found tears in his eyes. He was all disappointed by every judge in Tisazwari or Delhi or anywhere who had put that signature which was ditto the signature he would have done and lost it. His relatives were managed it. And who would look to that? What by management of the evidence now? Somebody managed the evidence to show this property he has transferred to me for this thing. Evidence is very important. Your litigation is a bird, it can't fly without evidence. Its wings are the evidence. It can't fly. Your rights, you can't assert unless there is evidence. You can't be taken as the son or the daughter of a person, or the husband or the wife or the brother and the sister of a person unless there is evidence. Your all property, other things depends only on evidence. That's how evidence. It's not merely few things, as I was talking in the story of the bad man's perception of law. Everything depends on evidence. And if I give you just a Quranic quote, God is also very conscious of things. He says, when you will be asked that did you commit this wrong, and it's one of the chapters of the Quran written, and he is the best of the legislators and the creators. He says, if you have done it, you will deny it, but your hands and feet will say, yes, we were made to do it. They will stand as a witness against you. Your eyes, your ears, your hands, your feet, everything will stand as a witness against you. Yes, we did it. These are documents. These are the devices of evidence. And then also,
At that time when Quran was revealed, God has written in the Quran, I shall identify all of you by your fingerprint. And after another 450 years, what happened? Today everyone is identified by the fingerprint. So it's all a matter of evidence. And today your QR code is like what Quran said then. And definitely when we find that history of the world, we find this wisdom was always there. But getting to this thing, that when we have to assert our rights, when we have to look to the liabilities, when we have to look to the punishments, when we have to look to the prosecution, when we have to look to the processing of the civil cases, evidence is there. And then we are living in a better part of the human history. Why? Because now we have electronic evidence. Now we have magnetic fields which can be read. Now we have all these things available with us, but we have to learn to manage it. We have to learn to manage it. Because everything leaves the traces. Your mobile phone is with you, it retains the whole of your story. What you say, what you talk, what you do, and everything. In the same way, you find everywhere CCTVs, and even in classrooms. You talk is preserved. A judge speaks in the court, everything is there. A culprit committed something, everything is there. So now is the story. It was, I believe, earlier also, but we didn't have the devices. We didn't have the devices. So in this age of electronic devices, how the evidence should work, how it should help us. That's why we have a new evidence law now. And this evidence system today, it has the capacity, more capacity of finding the truth. It makes proof easier. And that's why in the new Evidence Act, the electronic evidence and use of technology has been made prominent. If there is anything new in the new evidence law, that is the incorporation of the technology in it. Is anyone among us who is teaching evidence? Anybody is an evidence law teacher? I will not ask a question, I am just trying to facilitate. So, as I have a reading of the evidence law for so many years, I have seen these things, the relevance day, and then confession is important, dying declaration, then admissibility of documents, and like that, and then that's how earlier in section 65 there was this electronic evidence, and after the IT Act was enacted, and now it is in section 63, they have made it, and then in definitions also they have made it. So, I am trying to highlight the story that in what circumstances, with what minds, with what feelings, with what trickery, if I call it, with what skills of manipulation, with which skills of defilement. You have to work now in this world for the purposes of civil, criminal, public or any kind of litigation. It is a good opportunity that you are now more powerful, because you can monitor your home when you are in college. You can use whole of the technology to check who is coming, who is passing thereby, who is entering, who is doing this, who is doing that. That all you can do. But at the same time, yes, I'll give you time to raise the question, that I'm only putting the things in the background. And then at the same time, if we look to the nature of the crime today, worst situation is for children. Offenses against children. Very horrible position. Offenses against women. Frauds, bank frauds. Now it is not that kind of robbery with guns and all that. And then worst of it, manipulation of merit. Manipulation of merit is very important. It has a big impact. And then non-maintenance of property records. Efficient records. Monitoring of many other kinds of aspects of governance when technology is available there. So how best we can maintain all these things, and out of all that e-governance, I think what has to be focused much is the retention and protection of the documents and the protection of all the processes which take place, so that they can help in the court. And then you will find a better management of the evidence in the court, and you can have more and more convictions, and also honest ones will be acquitted by that. And that's how this system must be taken as an improvement on the earlier one, that yes, but a challenge is there. Do you have the trained persons to monitor the system? Do you have the sufficient equipment anywhere it is required? Then do you have sufficient integrity and honesty to present it in true context? Do you have a good defense protection system where it is not defiled or corrupt? Do you have the trained lawyer and prosecutor? And then do you have a trained judge? These are the questions which shall come. Otherwise, the admission of all these kinds of electronic gadgets as well as documents, admission is a welcome, and it's a very big leap forwards. And that's how we can have a better judicial system and management of evidence system in the country. So, who was trying to ask the question, please? Please ask the question.
So you are saying that in the beginning, as you had said, that reading leads to reading, then how does it leads to reading? How does reading?
The birds push the air by their wings backwards, and the body gets pushed forwards. And by the oar we push the water backwards, and the boat gets pushed forwards. This is how we have been doing it. There
I said, you great grandfather of Ravikant, you have been quite unjust, unfair, because you could not read. You could not read. You were knowing it. You were using it, but you left it to be read and expressed by Isaac Newton. He then said and formulated it. He read it formally and said, to every action there is an equal and opposite reaction. He converted this by his reading into knowledge. If you had done it, if you had said it, the story of the modern sciences would have started from India, not from Europe. So, you see the things, how the child behaves, but you never looked at what are the factors which make him behave like this. ज़्यादा से ज़्यादा आप ये कहेंगे ये भगवान की मर्जी है, but you don't read. You have to read the unwritten books. Sakshya Adinam is one book, but there are millions of books which are on the ground. Every case is a story in itself. Are you trained to read that story? And then when you are a legislator, you have to know much more, because you have to give the law to regulate in that mess, that complex situation. That's how. So once somebody is aware of it, he leads. And that's why the other day I always say, I'm sorry that Indian professors teach Austin and say, Austin said, law is the command of the sovereign. And why did he say it? Every Indian professor says, because he served in army. Every one of them, and a better one says, he knew Roman law. What hell of it, you don't read. He was a British jurist. He was an English jurist. He knew that his country is equivalent to few districts of Haryana. How can he rule the world? He can rule it by law. He had understood. You would understand कि मैं ऐसे तीर मार के world को करूँ, no. And that's how he raised the respect for law. He made people understand law is the command of the sovereign. He gave the justification, you have to obey it. And he gave the justification to it, if you don't obey it, you will be beheaded. There is no wrong in it, because you did not obey. That philosophy, Indian, these all people, including many, I don't want to name them, they did no justice to the Indian legal education system. They didn't write any good books. So, the question is, reading is to know the nitty-gritties, know the unseen, know the processes, currents and undercurrents, what's happening. That's very important. And today, law is based on prediction. It's a symbol. It has a symbolic value. It has to operate in future. Law is not a book of today like a newspaper. It is for future. Like a teacher and father and mother, they must find the future of the child in the child when the child is in the lab. A legislator must understand that what shall happen to the law after another 10 years, shall it serve any purpose or not?
I am not able to make an efficient dowry prohibition act. And what is the evidence system that is used for that? How is the evidence managed? Man, do you read? Have you read? Have you understood? And have you used the evidence in the court? So, you can't lead. When they found, yes, now this kind of thing cannot keep the world in my hand. I cannot keep all the territories under the Prime Minister of England. I shall give them freedom, political freedom to have, elect their own leaders, but system should be mine. System should be mine. Benefit should continue to flow to me. I shall give them a different economic system. I shall give them a different kind of social culture and fashion and other things. How can you do it? Which new subjects did you create when in the early part of 19th century, 1820 or so, Auguste Comte came up from France and developed the subject of sociology. Other one came, and today, who is popularizing the subject of psychology today? And who has developed the subject of industrial jurisprudence? And who developed the criminal laws, as you find? So it all depends that you read and you lead. And when you want to maintain the lead, you have to read. And that's how I would say that, dear friends, take this new evidence law very seriously. You will find much the same what was earlier, but you will find a lot of incorporation of the terminology which we developed with the advancement of information and communication technology. And information and communication technology is largely related to the retention of the data, and data is nothing but evidence. Your photograph, your fingerprint, your walking image, anything, that's all evidence and documents. And that's the best of the evidence. And there can be a revolution by this if it is properly done. Because everything comes under the record. Everything comes under the lens. And that's how, I talked of the offenses against children, the technology should be used to maintain the evidence of any of the offenders, right from a phone call up to anything done in the hidden place. You can trace it by the technology. Offenses against women, you can, anywhere, even if 1% threat is felt, have a mechanism that by the mobile phone the lady is informing the proper office that she is under some kind of threat, and that surveillance can be had by the local and central police offices anywhere, and you can have the evidence and catch the person. And then you can develop a very good system of maintenance of the documents. You find lot of litigation on property, isn't it? On title. Why there should not be, by the use of technology, maintain a very good record of the properties? And then if we have to do it otherwise, for example, there is a large number of these cases, service cases. So why don't we maintain a record from the day of advertisement? And we can do it. We'll have everything. Calculations, other things. These all documents can be, and there is a big question of pendency of cases. Why so? Because you are not able to lead the evidence. And it's not readily available. And therefore everything should be digitalized so that in the court of law, it takes you only 1 minute to produce the evidence and put it before the judge. Here is the evidence. So it can't be merely a task to be done by a law teacher in the classroom. The law teacher is doing his part, but what are the other departments doing? They have to look to it. It is not that they have to leave it to the lawyer to lead the evidence and another lawyer to have the counter evidence and the judge to hear it and decide the case at least not less than 10 years. Why? Why so? Why don't you have now, at this time I am here, let me say in 1 minute, how many bank transactions will take place? Millions? Is it? And there is a record of it. I am saying, why don't we have 100% voting now in elections? Why do we say 60% is sufficient, 70% is sufficient? And professors like Neelam, they don't want to go to the police station. When my bank transaction of even lakhs of rupees is quite safe, why can't I cast a vote by my mobile while sitting at home and having a sip of my coffee? Why can't I do it? Technology is advancing. Neither the American politician nor any other politician would like to have it, because it will be foolproof. And within an hour the results will come. Automatic computation, who is the president? And ladies will have more chance to become presidents. No, otherwise they are fearful of going to the campaigns, other things. So, see, evidence and law, these are inseparable. If there is no evidence, there is no law. When you stand in the court and say, Your Honor, my Lordship, he will say, who are you? I have my power with me. I have to click on this day for this thing. And for that, also, if somebody is responsible for the breach, he has to be punished. There has to be a law for this. And that's how, it's not that then anything, technology is not the last word, but technology cannot be undervalued also. Technology is the thing by which you can control a thief, a dacoit, a breacher, or a manipulator. It's by technology you can trace him, you can find it, and that's how you are going to so many things. But I am not here to fight for this thing that you do and you don't do it. But I will only say the breach, how I can plug those breaches. That is how the system works. That's how things can be done. So that's something which we already find it in the system. I would say we have found. I believe that the banking system, there are frauds, but it is working very soundly and in a very good way. So it can't be that when I should transfer something, when it rightly goes to the right account, it shall not go to the right place where it is centrally monitored. Yes, if there is a deficiency, the technology experts, they must work on it. We must make it possible. We have to make the world better. That's how, there can be any kind of system, there can be some difficulty, but they should work on it. That there should not be these kinds of things. How we can plug the deficiencies or make up the deficiencies and make the systems better. So if I say use digital technology for the protection and safety of women. I would not appreciate it. Anybody technician comes to me, no, there is possibility of breach. I will say still use it. I shall say and try to promote it. And then if all the records of the courts are put digitally and anybody will tell me there is a possibility of this thing, I will say okay, there is a possibility, but work on it that it is protected. Work on it that it is not in any way mutilated or in any way it is defiled or corrupt. Work on it. That's how we have to go in this digital world, and that's how this new evidence law gives this prime position to the technological evidence. We can't go without it. And the phone call is, how many cases are resolved on. To whom did she or she gave the last phone call before this thing? We go and start resolving it, start tracing out the things. We can't rule it out. So that's how this evidence law becomes very important. And please, if what I said, I'll be happy if there are disagreements on it. One came from him that he is not our technological experts will not be able to plug the breach. फिर ऐसा कर देते हैं, मैं चला जाता हूँ और मेरी याद आ जाएगी तो बात I have to go to my office and we also have this FDP, but I put it on at 1:30 because of this reason. Mr. Anirudh.
Sir, for your insightful session, I would now request everybody to stay seated. And I would call upon
present here. It is my privilege to deliver a vote of thanks for today's LDP on the topic Professional Excellence in the Legal Practice, organized by Center for Legal Studies, Bhartiya International Business School. I would extend my heartfelt gratitude and thanks to our esteemed guest speaker, Professor M. Afzal Wani, sir. Thank you for gracing this occasion with your presence, sir. Your enlightening words and profound insights have added immense value to today's session. Your expertise and deep understanding of the topic have not only inspired us but also provided us with valuable perspectives to navigate the dynamic legal landscape. I would also like to express my sincere thanks to our respected Chairman, Sir, Shri Anand Jindal, and Vice Chairman, Sir, Shri Anirudh Jindal, for their unwavering support to steer Bhartiya International Business School towards excellence in every endeavour. A special thanks goes to our Director, Sir, Professor Dr. Vikas Nath, for being a constant source of motivation for enabling the smooth execution of programs like these, which are integral to the growth of our faculty members and students alike. Lastly, I extend my gratitude to the organizing team, the faculty members, and all the participants for making this program a resounding success. Your enthusiasm and dedication ensure that such events become memorable success. Thank you all once again. Thank you, sir, once again for gracing the occasion. It's always a pleasure to hear you, and we always like to be associated with you for future events. Thank you all, and let's carry forward the knowledge and inspiration we have gained today and continue striving for excellence. Thank you all. Have a great day. I would request Neelam ma'am to present a memento to our guests as a token of great respect and gratitude. Please.
मैं तो सोच रहा था उतना भी बहुत So, okay, God bless you all.